Trustees of Swansea University Pension Insurance Scheme.
Yes, Mr. Krasner. Ms. Krasner.
Lady, my lords, I am Olivia Dobby and here on behalf of Mr. Williams this morning, who we'll refer to as the claimant here, and Mr. Keith Bryant and Mr. Saul Margot appear for the respondents. Firstly, may I check that your lordships and your ladyship have been handed up a copy of our speaking note for this morning?
Yes, we have.
It's got the little purple corner on it. I'm very grateful. Firstly, a very brief introduction. The facts relevant to our appeal are agreed. The claimant was employed as an IT technician for Swansea University from June 2000. Due to his disabilities, which are Tourette's syndrome, OCD and depression, he was compelled to reduce his hours to part-time working from October 2010. By mid-2013, when at risk of dismissal for incapacity, his employment was terminated on the basis of ill health retirement, and he was awarded an ill health retirement pension following a finding that he was permanently incapable of carrying on his work. Part of that ill health retirement pension was calculated using a form of averaging, a combination of his full-time and part-time service. That was called the accrued element of his pension. In contrast, and the part that we're concerned with today, the enhanced element of his pension utilised just his final salary, which for Mr. Williams was a part-time salary, in order to calculate the enhanced pension and the enhanced lump sum. The claimant brought a claim for disability-related discrimination under Section 15 of the Equality Act, claiming it was unfavourable to calculate that enhanced element of his pension using the final salary, which was his lower part-time salary. He'd been working part-time for much of his last 2.5 years of service just because of his disabilities, and had he not been disabled, he would have continued to work full-time. The claimant was successful at the Employment Tribunal, and then the respondent successfully appealed on the issue of unfavourable treatment to the Employment Appeal Tribunal, and that was upheld by the Court of Appeal. This hearing involves the meaning of the phrase treated unfavourably in the context of Section 15(1)(a). There's no need for us to rehearse the history of the litigation in respect to objective justification, but it is in the Statement of Facts and Issues.
Yes, well, they're commendably clear, and we've read those, and of course the printed cases, so we're fully au fait with the background.
We're very grateful, my lord. And the key focus of our submissions this morning will be on, as you'd expect, the Court of Appeal and the EAT judgments, and we'll take you to the relevant parts of those as necessary during our submission. So next to the order with which we present our arguments, our core submission will be that the Employment Appeal Tribunal and the Court of Appeal adopted an interpretation of Section 15(1)(a), unfavourable treatment, which was too narrow in scope. And in support of that, we will make the submissions under the following headings. Firstly, examining the context of unfavourable treatment, why the term unfavourably was chosen, the relevance of similar terms, which tests to apply, objective or subjective or mixed, and consideration of the scope of the previous protection. Next, we'll take issue with the finding that there can't be unfavourable treatment in the context of a benefit, including that which only the disabled receive. Thirdly, we will submit the Court of Appeal was wrong to say that Mr. Williams was simply complaining about something which was itself advantageous on the basis it could have been better, for we take issue with any suggestion that for him, unfavourable treatment simply meant insufficiently advantageous. And fourthly, we'll consider the examples that the Court of Appeal looked at and also address why Mr. Williams didn't advance other claims. And throughout, we will submit that the courts below failed to appreciate the correct balancing exercise in Section 15 available under the justification defence. I should note that we do use the words unfavourable and unfavourably interchangeably, and that's also done in the various judgments we'll come to, and indeed the Code of Practice. So Our first issue is the choice of the word unfavourably in the provision itself. Why was it used, and what's the significance of similar terms? We agree on the statutory intent behind that provision itself, and we would respectfully ask your ladyship and your lordships to firstly just go quickly to the wording of the section itself, which is in Authorities Bundle Volume 1, Tab 2, page 471. And we see there, very simply, a person A discriminates against a disabled person B if, little A treats B unfavourably because of something arising in consequence of B's disability. And A cannot show that the treatment is a proportionate means of achieving a legitimate aim. Issues of knowledge are dealt with in subsection 2. We are not concerned with that at all this morning, nor indeed with 1B. So we believe it's agreed that the intent of section 15 was to bring back the protection against disability-related discrimination as it existed before the case of Malcolm and Lewisham Council. That, as the Court may be aware, was a 2008 House of Lords decision in respect of a claim brought by a man suffering from schizophrenia who had let his social housing property in breach of tenancy. The local authorities started possession proceedings, and in his defence, Mr. Malcolm put forward disability discrimination. The House of Lords said there's no less favourable treatment, and their decision removed the utility from what was Section 3A1 under the Disability Discrimination Act, in that it rendered it no different from the direct discrimination provision which existed under that legislation. The crux of Malcolm was that the non-disabled comparator was deemed to have behaved in the same way, subletting in breach of tenancy, and therefore there was no finding of less favourable treatment.
Well, you say the purpose was to overcome that. How would Malcolm have been decided under the present law then?
Under the present law, because there's no need for the way that the present law is decided, one would look at Malcolm and one would say, because of its inconsequence of disability, we say that you would take away the fact of, for the reason for the treatment, you'd remove the fact of the subletting altogether, and Malcolm would have won the case.
What, you forget about the subletting?
Well, you'd come on to whether it was justified to a victim, of course. We're simply looking at that first element.
It might not change the result of the case.
Oh,
it would
quite.
just shift the.
It would shift at what stage the burden goes over to the local authority in that case to look at their justification.
You haven't produced Malcolm in your bundle, I don't think.
Well, we didn't put it in our bundle, partly because, my lord, we're agreed between us what the intent is of the legislation.
Malcolm's redundant now, in other words.
Yes, but in Malcolm there was a dissent by Lady Hale.
There was a strong dissent by Lady Hale where she said for years and years employment lawyers have understood less favourable treatment as being undertaken where one removes the reason for the treatment, therefore the hypothetical comparator would not have sublet. And she was the minority.
But is it your position and is it an agreed position that the change of words in section 15 was designed to give effect to Lady Hale's dissent?
Our submission would be absolutely.
Well, then I think it would be useful for the court to have that judgment so that they can appreciate what Lady Hale was saying.
My lord, we'll absolutely arrange for that. And can I apologise? The only reason we didn't put it in was because we didn't think it was contentious and we didn't want to...
It may not be contentious, but the whole purpose of this appeal is to give an interpretation to the word unfavourably.
We'll arrange for that.
Now, just while we're on it, you'll come to the question of whether unfavourably in 15 involves a comparison as
We will.
in the same way as 13.1.
We absolutely will
less
come to
favourable.
that.
What I don't see is any overview of the structure, which I didn't really get from your written submissions either, of the Act and how, for example, Section 13 and Section 15 tie together in the structure of the Act.
Well, my lady, can I take you back to tab 2 in our Authorities Bundle 1 and ask you to go to page 469 there, please. First page in tab 2. You have there Section 13, direct discrimination. And that's, if you look up above, you'll see that's part of Part 2 of the Equality Act, which sets out the key concepts. And here we have a number of provisions, direct discrimination, Section 15, discrimination arising from disability.
I'm asking you a really basic question.
Yeah.
How do those two concepts differ?
They differ in this way. If you're a disabled person bringing a direct discrimination claim, what you need to demonstrate is that you've been discriminated against, treated less favourably on grounds of your actual disability.
Whereas under Section 15,
Under Section 15, you're simply saying it's because of something arising in consequence of your disability. So if I'm dismissed for ill health absence and my absence was occasioned by my disability, I would be able to bring a claim, or try to bring a claim, under Section 15 because the absence is treated as something arising in consequence of the disability, whereas the absence itself is not the disability. If my
under Section 13, you're dismissed because you're disabled. Under Section 15, you're dismissed because there's an incident of your disability.
And, my lady, one further point. Section 15, in contrast to Section 13, has a justification defence. So under little b, 15.1b, there's only discrimination if A cannot show that the treatment is a proportionate means of achieving a legitimate aim. So you have the lower threshold of disadvantage in Section 15.1a, but the respondent or the employer is capable of justifying that treatment. Whereas in Section 13,
Well, there's no opportunity for
justification
on the direct discrimination.
putting aside age discrimination, which we're not concerned with today. My lady, I hope that...
Yes, it does, and you just said that that's the lower threshold, so unfavourably is, in your submission, a lower threshold than less favourably than others.
It's the reason why it is because you've got unfavourably because of something arising. So to get to you get to discriminating more easily under Section.
I see, because you can have an intermediary, whereas there is no intermediate fact in the.
So, for example, for a disabled an absence-related dismissal, unless someone says, I'm dismissing you because you're depressed or because you have a certain disability, you couldn't rely on that Section 13 claim. You might be able to rely on a Section 15 claim if you could say I was dismissed because of my disability-related absence, but then the employer has a chance to justify.
All that I was really trying to clear up was whether you were saying less favourably than was a lower hurdle than unfavourably, but that's not what you're saying, it's a different point.
It's the same level of disadvantage. We absolutely do say that.
Well, it's different contexts, isn't it? I mean, it's difficult enough, I think, to calibrate the level of favourability, but you say that you have to look at it through a different prism when you're looking at Section 15.
Well, we say in terms of the disadvantage encapsulated either by less favourable or unfavourable would be the same.
Yeah, right. Okay. And where do we go from here?
So I'm up to paragraph 4 on page 3 of my note. And just to explain briefly that before the case of Malcolm, the courts had followed a decision called Clark and Novacold, which had established that when you're bringing a disability-related discrimination claim, you compare the claimant to someone who the reason for the treatment doesn't apply. So that's why I said a moment ago, if you compare a Novacold comparator to the hypothetical person in the Malcolm case, that person wouldn't have sublet their tenancy. You take away the actual reason for the treatment in order to establish whether there was less favourable treatment. So that person wouldn't have faced possession proceedings at all. So the whole purpose of Section 15 was to bring back life into the concept of disability-related discrimination. And we say that's simply not contentious, and it's been set out in a number of authorities. We will just take you to one, an EAT case from 2015 called Hall against the Chief Constable of West Yorkshire. That's in your authorities bundle, tab 11, and we're going to start, please, at page 632. Miss Hall was claiming disability-related discrimination under Section 15 arising from acts before her dismissal and the dismissal itself. We're largely concerned here with what Mrs. Justice Lang said about the purpose of Section 15. And if your ladyship and your lordships look at paragraph 25 on 632, there's reference there to the case of IPC Media and Miller, which was where Mr. Justice Underhill, as he then was, referred to what Section 15 did, and he said Section 15 has no precise predecessor in the Disability Discrimination Act, but it does much the same job as was done by Section 3A1 of that Act, which prescribed disability-related discrimination prior to the decision of the House of Lords in Lewisham and Malcolm. We cannot see any difficulties about its meaning and effect. And then Mrs. Justice Lang goes on to describe at paragraph 26 the legislative history of Section 15. And she sets out how that section was dealt with under the previous legislation. And then at the top of page 633, sets out the actual wording of Section 15. At paragraphs 28 and 29, she deals with the explanatory notes to Section 15, which I'll come to shortly, but I will take you straight to paragraph 30 at the top of page 633, where 5 lines down from the top of the page, she says, I have no doubt at all that that Section 15 of the 2010 Act was enacted in order to restore the approach that had been taken by the Court of Appeal in the case of Clark and Novacold. Parliament had to use different language in order to achieve this from the language in Section 5 of the DDA as originally enacted because of the way in which the House of Lords had interpreted the language of Section 24 of the DDA in London, Borough of Lewisham and Malcolm. And she notes that His Honour Justice Clark took that approach in Land Registry and Houghton as well. A very brief aside, Section 24 of the DDA dealt with disability discrimination in the context of housing. That's why it was pertinent to the Malcolm case.
When she says it had to use different language, what's she talking about? I mean, we've got the DDA on paragraph 26.
She means in particular, my lord, that they had to leave the word less, the phrase less favourable behind to avoid the confusion that Malcolm had created happening again. And I'll take you in a moment to a Hansard debate for this purpose to show you that at the time there was real concern that Malcolm's situation could arise again, and there'd be a confusion with direct discrimination. Because as we saw from the current Section 13, direct discrimination continues to use the phrase less favourable, and there was a real concern to make the contrast.
So it is a critical point, the difference between less favourably in 13 and unfavourably in 15.
It is critical.
Yeah.
It is critical. But the reason for it, my lord, is because of what had happened under the Disability Discrimination Act and the need to redraft.
No, I mean, I understand the point. I hadn't realised it was quite such a critical distinction. Anyway, we'll see where that goes.
So could I take you over the page to 634, please, straight to paragraph 35. Before I do, could I ask you to note at paragraph 33 the comment about Baroness Hale dissenting on the comparator point? That's the reference that we've already discussed briefly to what happened in Malcolm. And I should just note halfway down that paragraph, that's Baroness Hale, paid close attention to the way in which the bill had evolved in its passage through Parliament and considered that this history supported the approach of Mumriel J. in Clark and Novacold. She considered her approach as also supported by a recent amendment to the DDA. She pointed out that Clark and Novacold had represented the settled understanding of employment lawyers of the effect of the provision for some 9 years. So going down to paragraph 35, EAT says here, against that background, it is clear to me, in the light of the language of Section 15 and of the decisions in Clark and Novacold and Malcolm, that Parliament's intention in enacting Section 15 was to reverse the effect of Malcolm and to loosen the causal connection which is required between the disability and any unfavourable treatment. So we submit that it's not contentious that Section 15 is intended to provide the same scope of protection as the previous provision under the Disability Discrimination Act before the case of Malcolm. Then we move on to the question of why was the term unfavourably chosen rather than any other. For example, why was unfavourably used and not detriment or disadvantage? Other terms which we all agree have a similar meaning. On behalf of Mr. Williams, we contend that the reason why unfavourable treatment was used was simply to contrast with less favourable, rather than making the test for disadvantage any harder to meet. Unfavourable made the clearest contrast with less favourable, trying to leave the sense of any comparative exercise behind. Now, next, we take you to what the EAT said about this, because part of our case is it wasn't that the unfavourable was used to say anything different from a term such as detriment. In your core volumes at page 139, we find paragraph 27 of the EAT judgment. And Mr. Justice Langstaff says under that heading unfavourably, as to the reasoning by reference to other possible discrimination claims, the meaning of the word unfavourable cannot, in my view, be equated with the concept of detriment used elsewhere in the Equality Act. The word unfavourably is deliberately chosen. So too, the choice not to use the word detriment must be assumed to be deliberate. The draftsman would have been well aware of the use of the word detriment elsewhere in the Equality Act and avoided it. Nor, as the parties were agreed, does the word unfavourably require a comparison with an identifiable comparator, whether actual or hypothetical, as would the description less favourable. Less invites evidence to be provided in proof of less than whom. Un is, by contrast, to be measured against an objective sense of that which is adverse, as compared to that which is beneficial. Our first point in reaction to that is that we suggest there's a rationale for the basis of why unfavourably was chosen. And that rationale is not that there was an attempt to avoid the meaning conveyed by the word detriment. In fact, in the bill itself, in the Equality Bill of 2009, the original clause 14, which then became section 15, used the word detriment itself. To show you clause 14, I'm going to have to ask you to turn to our appendix 3, please, because that's where we can locate that clause. It's from part of the skeleton argument for the Court of Appeal, and it's at page 389 in your appendix part 3. And at the top of the page, one sees 14, discrimination arising from disability. And the clause was drafted like this: a person, A, discriminates against a disabled person, B, if A treats B in a particular way, because of B's disability, the treatment amounts to a detriment, and A cannot show the treatment's a proportionate means of achieving a legitimate aim.
So how does that help you?
Well, what we know is that that wording, treatment in a particular way which amounts to a detriment, becomes, in section 15, simply unfavourable treatment.
Yeah. So it suggests they wanted to use a different term.
Well,
They thought it meant something different.
well, our submission is the reason why they changed it was not because it was thought that detriment meant something different from that which the draftsman wanted to convey. And we can show you that, we submit, by looking at what key Hansard debate said about that.
I mean, are we entitled to look at that? Surely it's...
Yeah.
My Lord, we've considered that, and the reason why we say the court is entitled is because we're relying on it to look at the context that section 15 came into being from.
I mean, the point being made in the EAT is a different one. Detriment is used elsewhere in the Act as enacted. Is that right?
Mr. Justice Langstaff says unfavourable. They'd have used detriment if they wanted to use detriment. They chose to use
So
unfavourable.
they say a detriment is used elsewhere within the Equality Act. And I don't know whether we have the sections where it is used, but
We do have.
that would be much more relevant than trying to dig
Well,
around in the Hansard.
My
Well,
Lord,
I think of more pertinence, the respondent in its case says that you don't meet the criteria in Pepper and Hart. First of all, you're not dealing with ambiguity. And secondly, in any event, there is no clear statement which removes any doubt in the parliamentary statement. Obviously, de bene esse, we have read your quotations from Hansard, but what do you say to the argument that you failed at the first hurdle?
We've put an extract from Bennion into our bundle to show that this is about non-Pepper and Hart use. It's looking purely at the context and the mischief for which the Act was designed to address.
Yes, well,
And for that
Pepper
reason,
and Hart has undergone various episodes of eliding over the years, but I mean, is there a recognised category for looking at Hansard where you're trying to divine the purpose of the legislation?
My Lord, we would say there is when you're trying to supply context or and here identifying the mischief at which the legislation was aimed was simply this, trying to get away from the confusion Malcolm had created and return to the Clark and Novacold situation.
But that's an agreed position, and therefore surely it would be more useful for us to study what it is that the law is in the Clark and Novacold position.
Well, my lord, may I take you to
Well, look,
the Hansard debate, and you can
I was going to
decide-
say, let's have a look at it very briefly.
Yes, I won't.
And
I won't be long on
we'll
it.
decide ultimately whether it assists us or and
Thank you.
is admissible. Yes.
So in volume 2, at tab 29, page 1030, this is from a debate on the 16th of June 2009, and at 1030, at the top of the page, we have the Solicitor General, then Vera Bard, talking about what the intention of what was then Clause 14 was trying to do. And she says, like the provision in the 1995 Act, Clause 14 is intended to provide that the disabled person demonstrates that they've been subject to detrimental treatment because of something connected with their disability, and secondly, that the duty holder should be able to justify that treatment. However, we have revised the wording from the 1995 Act because we cannot simply carry it forward, as the finding in the court said that we did not achieve the protection that we intended. We therefore dropped the requirement for a comparator. Now, in part of this debate, my lady, my lords, there was a suggestion that another amendment to Clause 14 be made, which was very much more complicated. And the Solicitor General wasn't keen to introduce more complexity into her clause. And she says at the bottom paragraph of 1030, having described her reservations about the amendment which the debate was discussing, as I have made clear, we are open to the disabled lobby's arguments that we should alter Clause 14 to make clearer and different from we should alter Clause 13 to make it clearer and different from Clause 13, that was and remained direct discrimination, in order to re-register the difference between disability as a protected strand and all the others. So, in our submission, the reason for changing to the final wording, unfavourable, and not keeping the word detriment, was motivated by two factors. Firstly, the desire to draw an even clearer distinction with the previous phrase, less favourable, which had led to the problems in Malcolm, and secondly, concerns that there needed to be an even clearer distinction between direct discrimination under Section 13 and the special protection afforded by Section 15. So whilst we don't take issue with the EAT saying...
Sorry, you haven't answered my question, which is where one finds the word detriment used in the present Act, which is the point that the EAT were making.
Well, one place where we find it is Section 27 of the Equality Act, which you'll find back at tab 2 of your Authorities Bundle number 1,
No.
at page 480. And that deals with victimisation. And 27.1 reads, a person A victimises another person B if A subjects B to a detriment because B does a protected act or A believes B has done or may do a protected act. So in section 27, we have there, subjecting B to a detriment is something which is done to B, an act or an omission, just as we would say under section 15, treating B unfavourably is the thing which is done to B by A. So that's one place where detriment appears. And on the page right next to that, 481, we have section 39 of the Equality Act, and that section is important that one has to go through in a case of workplace discrimination, in contrast to pension discrimination under section 61, which Mr. Williams relies on. But in section 39, if one looks at 39.2, an employer A must not discriminate against an employee of A's B as to terms of B's employment in the way A affords B access or by not affording B access to opportunities for promotion, transfer, or for training, or for receiving any other benefit, facility or service, by dismissing B, and D, by subjecting B to any other detriment. So the way detriment is used there is as of the consequence of the act itself.
But I mean, presumably in the bill, detriment occurred in all these places, and I suppose your point is that really, insofar as one can infer the draft's intention, bringing in unfavourably makes a rather clearer contrast between with less favourably in section 13.
That's exactly our point, my lord.
And that would fit in with your general approach. Yeah.
Right, where are we now in your speech?
I'm just about to take you to the explanatory notes to the Act, because in our submission, those show very clearly that Section 15 was and remained concerned with the kind of disadvantage which is very similar to a detriment. And
Just before we go there, that you were quoting the Solicitor General in the parliamentary debates. At that time, had the text of the bill been changed from referring to detriment to no?
It was as it was. That's clause 14 then.
Yes.
Came out, there was only one more change after that, and
Yes.
it went to.
So how can we use, in any event, what the Solicitor General said to justify clause 14 to interpret the rewording later?
Well, we look at what the Solicitor General said about what was the current status of clause 14 then, in June of 2009, and ask you to infer that when the wording changes to unfavourable, it's for the reasons that have been expressed in that debate. You can make that inference without the debate itself, because we say it's crystal clear from what had happened in the legislative history beforehand, particularly with the impact of Malcolm. But I take you next to the explanatory notes, because the way they read shows that they still retain the word detriment. And you'll find those in our case, please, at page 50. That's 50 in the core volume. And page 50, please, in the core volume. And could I take you to the background, which is paragraph 70 in the box on page 50. That provides, this section is a new provision. The Disability Discrimination Act 1995 provided protection from disability-related discrimination, but following the judgment of the House of Lords in the case of Lewisham and Malcolm, those provisions no longer provided the degree of protection from disability-related discrimination that is intended for disabled people. This section is aimed at re-establishing an appropriate balance between enabling a disabled person to make out a case of experiencing a detriment which arises because of his or her disability, and providing an opportunity for an employer or other person to defend the treatment. We say if there was a clear intention to change the meaning from clause 14 of that bill to section 15 of the Act itself, surely these notes would have required an overhaul to eschew the normal test for detriment, stating that something far more stringent is required. And what we see instead in paragraph 70 is the very word detriment remains there. Now, the respondents have said that the explanatory notes don't purport to explain the meaning of the phrase unfavourably. They go to the case of Westminster City Council about that. We say that that case actually helps us with our reliance on the notes themselves. And can I ask you to go to tab 28 in Authorities Bundle 2, please, starting at page 1013. I can take this very briefly. You'll see at paragraph, the top of page 1013, Lord Staines says there, since explanatory notes are sometimes placed before the House, it would be sensible to clarify their status. And going straight down to little c to d, please, His Lordship says, the notes are intended to be neutral in political tone. They aim to help to explain the effect of the test and not to justify it. The purpose is to help the reader get his bearings and ease the task of assimilating the law. And then down to paragraph 5, please. Question is whether in aid of the interpretation of a statute, the court may take into account the explanatory notes, and if so, to what extent. The starting point is that language in all legal texts conveys meaning according to the circumstances in which it was used. It follows that the context must always be identified and considered before the process of construction and during it. Therefore, wrong to say court may only resort to evidence of the contextual scene where an ambiguity has arisen.
Yes, I mean, what
That's
he's saying there, which is, of course, it's a fairly informal process. You get your explanatory notes with the bill, and then they update it. It may not be a perfect approach. So I suspect that paragraph 70 probably was in the form that it was in the bill,
My Lord,
and no one changed it.
Well,
I mean, they changed 69, but they don't seem to change 70.
Well, they kept 70, although all other parts of the notes do change.
But they being officials who are not Parliament, and we're not bound by what they say. And
We're not bound by it, but our submission is that the very fact that if detriment wasn't intended to convey any sense of the meaning of unfavourable, why would it have stayed in paragraph 70? It would have made no sense. And we also draw assistance from the Code of Practice that was published when the Act came into force. Could we ask you to turn to page 55 of our case now? That's in the Corvundle at page 55.
Sorry, para 55 or page 55?
Page 55, please. And the little box at the top of the page is setting out section 15, subsection 4 of the Equality Act 2006, because that requires the code to be taken into account by a court or tribunal in any case in which it appears to the court or tribunal to be relevant. So that tells us about its status. And then we take you to paragraph 1.9 of the code in the middle of the page, which says the main purpose of this code is to provide a detailed exploration of the Act, will assist courts and tribunals when interpreting the law. And then, importantly, we come to paragraph 5.7, which is the paragraph giving guidance as to what is unfavourable treatment. That reads, for discrimination arising from disability to occur, a disabled person must have been treated unfavourably. This means he or she must have been put at a disadvantage. Often the disadvantage will be obvious and it will be clear that the treatment has been unfavourable. For example, a person may have been refused a job, denied a work opportunity, or dismissed from their employment. But sometimes unfavourable treatment may be less obvious. Even if an employer thinks that they are acting in the best interest of a disabled person, they may still treat that person unfavourably. So we see that in paragraph 5.7 itself, the term disadvantage is incorporated into the definition of unfavourable. We take you next to the next page in our case, where you see the extract from the code addressing the question, what is a disadvantage? That's 4.9 of the Code of Practice. That says disadvantage is not defined by the Act. It could include denial of an opportunity or choice, deterrence, rejection, or exclusion. The courts have found that detriment, a similar concept, is something that a reasonable person would complain about, so an unjustified sense of grievance would not qualify. A disadvantage does not have to be quantifiable, and the worker does not have to experience actual loss. It's enough that the worker can reasonably say they would have preferred to be treated differently. So there we see a have a likening of the concept of disadvantage to that of detriment. And then we take you next down our page, to page 56, to the part of the code that deals with what is a detriment, and this is in the context of section 27, victimisation, and it's paragraph 9.8 of the Code of Practice. Reading, detriment in the context of victimisation is not defined by the Act and could take many forms. Generally, a detriment is anything which the individual concerned might reasonably consider change their position for the worse or put them at a disadvantage. This could include being rejected for promotion, denied an opportunity to represent the organisation at external events, excluded from opportunities to train, or overlooked in the allocation of discretionary bonuses or performance-related awards. So we submit it's important there to construe unfavourably in its context, and the proper approach is to look at the meaning of the similar words, as the maxim res nociter risosis says. And in the House of Lords case of Shamoon, which is largely encapsulated in that paragraph 4.9, what is a disadvantage, Lord Hope relies in that case on that maxim. And whilst we agree that these terms unfavourable, detriment and disadvantage all have a similar meaning, we don't need to, and we don't, of course, go so far to say they are exactly the same. But even though in some places in the Equality Act, the term detriment is used as the consequence of a disadvantageous act, there's very, very often no distinction between them, and they're often treated in exactly the same way, as is in the case of Equant, a 2007 employment appeal case, which was concerning a bonus under the previous incarnation of Section 15, Section 3A1D of the Disability Discrimination Act. Could I ask you to go to tab 9 in the first authorities bundle at page 581, please? And here the court is considering whether an act, which is largely relating to a bonus here, constituted unfavourable treatment of the appellant, causing him or her detriment. And the EATs say, we've run these together, not least because of our view of the helpfulness of Lord Justice Smith's 3 stages in her judgment, but she did not specifically mention detriment. Now, this is the important part. These two concepts are separate, one arriving from Section 3A1A and the other from Section 4.2D. Just as an aside, my lady, my lords, 4.2D was the predecessor to Section 39.2, which we've already looked at in the Equality Act. But it is often very difficult to see the distinction between them. Plainly, there can be unfavourable treatment which does not lead to detriment if there is nothing which can be described as loss or injury caused, or even emotional damage suffered to or by the victim, bearing in mind the low level of requirement of detriment, which has been made clear by a number of cases, culminating in Giad and Byford and Shamoon against Chief Constable of the IUC. But there could be situations in which detriment was suffered, but there was no unfavourable treatment. In this case, we are satisfied the two can satisfactorily and sensibly be approached together. In doing so, it's important to bear in mind the words of Lord Hope and Shamoon at 35, as approved in the House of Lords decision in St Helens. The House of Lords and Shamoon and St Helens emphasise that the question of detriment must be looked at from the point of view of the victim, and as we've indicated, it is not a high hurdle or burden for the victim to satisfy to show that detriment has been suffered. So, Equant is considering the point of view of the victim here, and that's the application of the mixed subjective-objective test, which, as the EAT points out here, is set out in Shamoon and other cases.
Can I just ask you?
Of course.
Do you endorse the reasoning here, the detriment being the consequence of the unfair treatment? That distinction between them?
For section 42D, which is now 39.2, that is the distinction between them. They're used in those different places in the Equality Act as well as in the DDA of 1995. But that's not the only place that detriment appears in the Equality Act, which is why I took you to section 27, the provision dealing with victimisation, where there detriment is also used to describe an act or omission done by the perpetrator to the alleged victim.
Right.
Detriment can be suffered where there's no unfavourable treatment. That's what said.
That can happen if there's no legal wrong.
So they cannot be regarded as synonyms.
Well, we don't need to go so far to say that they mean they are the same concept. It's enough for us that they mean similar things, and that's what the Code of Practice says and cross-refers to these three terms: unfavourable, disadvantage, and detriment. And just one more point to note about that paragraph 34, Equant's case. Your Lordships and your Ladyship may note there that the EAT uses the term unfavourable treatment 3 times, even though they're talking about the concept of less favourable treatment under the Disability Discrimination Act. We submit that if unfavourable was so obviously different a standard from to be applied under the previous legislation, the EAT wouldn't have used that term interchangeably. So looking at the test to be applied for when detriment takes place, the first point...
Sorry, why are we doing that?
I'm just looking at what's been said in Equant about the mixed test.
I know, but why are we concerned with that? I mean, we are construing the word unfavourably as it occurs in section 15.
Well,
and we're not concerned with the term detriment.
My
It
Lord,
doesn't appear in section 15.
My Lord, the reason why we look to the mixed test as set out in Shamoon for detriment is because the EAT in Williams have said that an objective test is to be used to determine unfavourable treatment. And we take issue with that, and because it provides far too high a threshold of disadvantage.
Right, we're on page 6 of 22 of your speaking notes, so you better crack on.
So the test in Shamoon is one which says you take into account the stance of the reasonable victim. It's the mixed subjective objective test. And it's useful for us to compare what the EAT and the Court of Appeal said below about that, because our submission is they got it wrong. Could we ask you to turn to volume, page 140, please? Part of the EAT judgment.
Which paragraph?
Paragraph 29, please. About 8 lines down that paragraph, Mr. Justice Langstaff says, the determination of that which is unfavourable involves an assessment in which a broad view is to be taken, and which is to be judged by broad experience of life. Persons may be said to have been treated unfavourably if they are not in as good a position as others generally would be. What's the contrast between that part of the judgment and with what's said about the mixed test in Shamoon is notable, we submit, because it's a real contrast with looking at the perspective of the reasonable victim. And for that reason, we ask you to go now to Shamoon itself, please, which is at tab 27 of your second authorities bundle at page 974. What Lord Hope is talking about here is how one determines what a detriment is. He's dealing with the Article 8.2b, which is the Northern Ireland equivalent of what is now Section 39.4 of the Equality Act. And he says the statutory cause of action, paragraph 34, which the applicant has invoked in this case is discrimination in the field of employment. So the first requirement, if the disadvantage is to qualify as a detriment within the meaning of Article 8.2b, is that it has arisen in that field. The various acts and omissions mentioned in the article are all of that character, and so are the words by dismissing her in Section 8.2b. The word detriment draws this limitation on its broad and ordinary meaning from its context and from the other words with which it is associated, res nocita sociis. And then he goes on to say, as Lord Justice May put it in de Souza, the court or tribunal must find that by reasons of the act or acts complained of, a reasonable worker would or might take the view that he had thereby been disadvantaged in the circumstances in which he thereafter had to work. So that adoption of the reasonable worker test is applied and used for whether a detriment's established.
But is that a mixed subjective objective?
It is a mixed test because
How?
It takes the victim's stance and applies a reasonableness check or balance to it.
Well, I mean, isn't it purely objective? Because it is rather like in contract, you don't look at the subjective intentions of the parties. You ask what reasonable people in the shoes of those people would have done. So,
well, my lord, we say it does have the subjectivity of what the victim experienced attached.
did Lord Hope say anything about it being a mixed test in Shamoon?
Well, our submission is that when you're looking at what the reasonable worker is, that indeed is looking at what the individual is experiencing, but with a reasonableness valve attached to it.
Well, that is your submission, but does Lord Hope support that submission?
Lord Hope supports that when we go further up and see the other cases relied upon at the top of page 974, looking at the case of MOD against Jeremiah, where Lord Justice Brightman had said back in 1980 that a detriment exists if a reasonable worker would or might take the view that the treatment was in all the circumstances to his detriment.
That's the same test, isn't it?
Well, what one's doing is, particularly we say where in cases where discrimination is involved and the experience of the individual and the consequence on them is pertinent to take into account. One looks at what that individual experienced and then asks, is that a reasonable approach to take? And my lord, that's an approach which is applied throughout the Equality Act. For example, if one goes back to tab 2 in our authorities bundle, we look at the definition of harassment under section 26 of the Equalities Act, page 478, please. Harassment takes place if A engages in unwanted conduct relevant to a relevant protected characteristic, and the conduct has the purpose or effect of violating dignity or creating a specific environment for B. But going straight down to subparagraph 4 towards the bottom of the page, in deciding whether the conduct has the effect referred to, each of the following must be taken into account: perception of B, the other circumstances of the case, whether it's reasonable for conduct to have that effect. So there, my Lord, we say,
there's a clear statement.
There's a clear
that
statement.
B's actual perception is part of the test. But how do I transfer that into Shamoon?
One does, my Lord, because when one's looking at what is a detriment, you're looking at anything as the code of practice we went to before at paragraph 9.8. That was anything the individual concerned might reasonably consider had changed their position for the worse or put them at a disadvantage. Quoting there from paragraph 9.8.
9.8 of, sorry.
Of the code of practice.
Code of practice.
I've noted it in the case before, but in your authorities bundle, it's 1057, tab 33.
Right.
So I'm going to move on as I've got some way to go. In the EAT judgment, at paragraph 27, on page 139 in the core bundle, at the bottom of that paragraph, Mr. Justice Langstaff says, less invites evidence to be provided in proof of less than whom. Is, by contrast, to be measured against an objective sense of that which is adverse compared to that which is beneficial. And Mr. Williams' concern about this is that introducing a purely objective test is firstly a more stringent one than other provisions in the Equality Act, and secondly, it's a more stringent test than applied under Section 3A of the DDA, its direct predecessor. And our submission is, if Mr. Justice Langstaff is there saying an objective test is to be applied, that narrowing of the test can't be right, especially when an express intent behind this new provision, Section 15, was to re-engage the scope of protection which was afforded to disabled persons prior to Malcolm. Now, in Shamoon, the test which was adopted for detriment, that, as we've already shown when looking at the code of practice, was taken into the concept of what is a disadvantage as well. And we submit that that should be applied to what is an unfavourable as well. And the reason for applying a mixed objective-subjective test in Section 15 would be to give the broad reach of protection intended by Section 15, remembering in particular that there's always an opportunity for the employer to answer such a claim through the objective justification defence. I want to take you to one more part of the Code of Practice, please, which is in our Appendix 3A, which is the part that's been added in quite recently. I think you'll have that in hard copy. Appendix 3A.
We do have it electronically as well.
And at page 349 in that Appendix 3A, page numbers in the bottom middle of the page, we've got an extract from the code dealing with Section 13 of the Equality Act. That's less favourable treatment. And at paragraph 3.5 in the middle of the page, it reads, the worker does not have to experience actual disadvantage, economic or otherwise, for the treatment to be less favourable. It's enough that the worker can reasonably say they would have preferred not to be treated differently from the way the employer treated or would have treated another person. So that's another place where you're looking specifically at the worker in question, the worker who experienced this disadvantage. And our submission is, firstly, that's evidence of another place in the Equality Act where one's looking at that reasonable worker test of disadvantage. And secondly, if that's a test applied to define both disadvantage and less favourable, why should the scope of disadvantage under unfavourable treatment be any different? And we remind you that when the Code of Practice refers to Section 15, it itself uses the term disadvantage, and that's paragraph 5.7. And the last point we make about 5.7 is to remind your ladyship and your lordships that the content of that guidance suggests in our submission that there is intended to be a mixed test there because of these reasons. Firstly, it points out that the employer may not realise that the treatment is unfavourable. And secondly, it looks at situations where unfavourable treatment is less obvious. If treatment has got to be objectively negative to qualify as unfavourable, surely the hypothetical employer in this example would understand that their treatment had that effect, and there wouldn't be the need for the caveat about more subtle treatment. And if indeed the test under Section 15 was a purely objective test, as Mr. Justice Langstaff suggests, surely the Code of Practice would need to have set out the contrast between this section and the other provisions of the Equality Act we've looked at. And of course, there is no such statement. It's also the case that if unfavourable is to be determined looking at an objective test, this would apply to pregnant women as well under Section 18 of the Equality Act. It would mean that pregnant women would have to satisfy this more difficult, purely objective test with no regard to their subjective experience. And we ask you to have regard to these other provisions of the Equality Act in support of our contention that Parliament would not have intended Section 15 to be interpreted as requiring a high level of disadvantage. So at page 8, at the top of the page, you see our little A, that's Section 19 dealing with indirect discrimination. We say there there's a low threshold to be taken into account with what disadvantage means, and we've already taken you to paragraph 4.9 of the Code of Practice. Section 20 is the reasonable adjustments provision, and that requires the level of disadvantage to be, it's called a substantial disadvantage, but that only means disadvantage which is more than minor or trivial. So our submission is that's also low test, and we've given you the reference for the interpretive provision, Section 212 of the Equality Act. Section 26, dealing with harassment, I've already taken you to that provision in page 478 of our bundle, where you see that mixed test in Section 26, subsection 4. And likewise, we've already taken you to the Code of Practice on Section 27, victimisation, which includes as being subject to a detriment anything which the individual concerned might reasonably consider changed their position for the worse. So I emphasise those words, the individual concerned, that clearly is a mix.
So where are you reading from?
I'm reading from little d and quoting from that paragraph 9.8 of the Code of Practice.
Oh, sorry, back to Code of
I'd
Practice.
originally taken you to that in our case, but I'm just quoting those words here. So our submission is surely the reference to the individual concerned clearly indicates that mixed subjective-objective test. And lastly, in terms of Section 13, less favourable treatment, well, I've taken you already to the Code at paragraph 3.5, which takes into account the perspective of the worker in question. and indeed the low threshold. One more brief point to make about section 13, direct discrimination. The Court of Appeal suggested that Mr. Williams' case rested on a comparison with other disabled people. And can I take you to where they say that? It's paragraph 49 of the Court of Appeal judgment in your core volumes at page 122. At paragraph 43, Lord Justice Bean says, 2 lines down from that paragraph, top of the paragraph, his, Mr. Williams' pension is undoubtedly less advantageous or less favourable than that of a hypothetical comparator suddenly disabled by a heart attack or stroke, but it is far more advantageous or favourable than it would have been if he'd not become permanently incapacitated from his job. Just pausing there, the reason why that's said is because under the pension rules that we're dealing with here, final salary is used to calculate the enhanced element. And if one had a sudden illness, such as a heart attack or a stroke, it's not the same as having a disability which causes your work to go down to part-time before you're permanently incapacitated. You could be immediately permanently incapacitated. But we say that is a red herring, that suggestion, because Mr. Williams does not here rely on any comparison with persons with different disabilities. He doesn't need to, and it's not what Section 15 requires. Comparing oneself to people with different disabilities is more akin to a direct discrimination claim under Section 13, because that caters for discrimination on grounds of the disability itself, covering both differential treatment between categories of people with different disabilities and also between disabled and non-disabled persons. Mr. Williams wouldn't succeed on a Section 13 claim in any event because of causation. He may have been treated differently because of working part-time hours, but he wasn't treated differently directly because of his disability. That's never been how he puts his case. So, moving on, a short point about whether the objective test that Mr. Justice Langstaff would be the end of the road for Mr. Williams. Mr. Williams says that even if that objective test was right, he should still win under it because a reasonable worker, not himself looking at his own perspective, but just the objective bystander, would feel hard done by in the same circumstances as Mr. Williams, who had worked for the vast majority of his career full-time, and that full-time work being totally disregarded in his calculation of the enhanced part of his pension as though it never happened, even though his reduced hours were entirely due to his disability. But we say that the lower threshold is all that's required for unfavourable treatment, and of course the respondents have the opportunity to justify that treatment when it gets to that stage. And the courts below seemed at various times to forget that the disadvantageous treatment that Mr. Williams was complaining about was not, of course, the overall receipt of the pension. It was the specific calculation within the pension rules which used final salary only. It was the incorporation of a metric which was tainted by disability to his detriment. Now, we move on to saying the decision of the courts below that Mr. Williams had not suffered unfavourable treatment can be shown to be wrong because under the old legislation, the Disability Discrimination Act, Mr. Williams would have won. Now, we're quite clear that Section 15 doesn't require you to adopt a comparative approach. However, it's a useful litmus test when determining the correct scope of Section 15 to consider how Mr. Williams would have fared under Section 3A1 pre-Malcolm. And the reason for that is we all agreed that that was the intent on enacting Section 15 to reverse Malcolm, but retain the same level of protection as it existed in the Clark and Novacold days. Well, in terms of how this exercise is to be undertaken, the respondent agrees with us as to who the correct comparator should be. That is, someone who was able to work full-time. With reference to where in their case they agree that, it's page 78 to 79. I don't need to take you to that. Such a person, we submit, that comparator would not get an ill health retirement pension, but they would receive their full pay as they kept working to their normal pensionable date and then get their full pension. Under the old test, one would be applying the comparator from Clark and Novacold. And I do need to take you briefly to that case in order to show you how Mr. Williams would fare under that section. It's tab 5, please, in your first authorities bundle, and I'd like you to turn, please, to page 523. We could start just below little b on page 523. My Lord Justice Mummery is looking at the correct approach under this section 3A1. And His Lordship says, but as already indicated, the Act of 1995 adopts a significantly different approach to the protection of disabled persons against less favourable treatment in employment. The definition of discrimination in the Act of 1995 does not contain an express provision requiring a comparison of the cases of different persons in the same or not materially different circumstances. The statutory focus is narrower. It is on the reason for the treatment of the disabled employee, and the comparison to be made is with treatment of others to whom that reason does not or would not apply. The others with whom comparison is to be made are not specifically required to be in the same or not materially different circumstances. They only have to be persons to whom that reason does not or would not apply. And we interject there saying, for Mr. Williams, the reason is he can't work full time. And then could we go down to the bottom of the page to H, please, where the court says this interpretation is also consistent with the emphasis on whether the less favourable treatment of the disabled person is to be justified. That defence is not available in cases of direct discrimination under the Other Discrimination Acts. And, my ladies and my lord, that point remains good for the Equality Act. The broader reach of the comparator is matched with the possibility of objective justification. Over on page 524 to 525, Lord Justice Mummery looked at two key examples that were in the guidance to the Disability Discrimination Act. A famous one to do with a guide dog and a blind man in a cafe, and then another example about a disabled customer who had difficulties with her eating was asked to leave a restaurant. I don't have time to take you through those now, but I will just go to the pithy summary at page 528, please, where Lord Justice Mummery says at C, in brief, the legal position is less favourable treatment of a disabled person is only discriminatory under section 5.1. That then became 3A1 if it is unjustified. Treatment is less favourable if the reason for it does not or would not apply to others. In deciding whether that reason does not or would not apply to others, it's not appropriate to make a comparison of the cases in the same way as in the Acts of 1975 and 1976. Those were Race Relations and Sex Discrimination Acts. It is simply a case of identifying others to whom the reason for the treatment does not or would not apply. The test of less favourable treatment is based on the reason for the treatment of the disabled person and not on the fact of his disability. It doesn't turn on a like-for-like comparison with the treatment of the disabled person and of others in similar circumstances. So, when drawing those principles and applying them to Mr. Williams' case, we would say this authority, which, as we know, was followed for years and years until Malcolm, requires the court to extract or remove the reason for the treatment as well as the disability itself. And here, the reason for the treatment was the inability to work full-time, leading to the reduction in hours and ultimately permanent incapacity for work. And from this, we can see that the correct comparator, if this was being done under the old test, would not be eligible for ill health retirement. However, we submit that using that correct Clark and Novikol comparator, the full-timer actually fares better in respect of pay received overall, pension being a deferred form of pay, and better still after retirement because their pension, when ultimately received, is based on full-time working throughout. Now, the courts below disagreed with us because they said, firstly, the EAT, paragraph 25 of its judgment, by comparison with any non-disabled person, a former employee having taken ill health retirement would be treated favourably. And the the Court of Appeal addressed this at paragraph 43, which is at page 122 of your core volumes. This is the fourth line of that paragraph. But it's being the pension, it is far more advantageous or favourable than it would be if he had not become permanently incapacitated from his job. However, we say it's wrong to describe those things as favourable or advantageous because what both courts do below is to ignore, firstly, the fact of the permanent ill health and the implications that that has on not being able to work and earn a salary anymore. And secondly, the very fact of the comparator retaining good health, the ability to earn a full-time salary, and then the full pension at eventual retirement. Disability had an ongoing impact on Mr. Williams here. He was incapable of working further. Indeed, the respondents retire on the generosity of the pension scheme, both at the point of ill health retirement and on an ongoing basis, receiving the pension year after year. But we say they ignore the ongoing position of the comparator who is able to and does carry on working full-time. If you're going to look at the pension scheme's impact on the disabled worker and the benefits that imparts, one needs to likewise look at the ongoing financial position of the hypothetical comparator. And we've done an illustration as to how those two individuals would fare at the back of our Appendix 3, please. If you could turn to page 456 of the appendix. My lady, my lords, if you could look at the middle row, which has at the left-hand box, projection of income received from appellant's effective date of termination to normal retirement date, normal pensionable date. You see under the heading appellant, Mr. Williams is receiving an annual pension of just over £10,000 a year for those number of years, and the Clark and Novikol comparator would be receiving their annual salary. Mr. Williams also receives his one-off lump sum of just over £20,000. And after, you can see from those figures alone, after a year, Mr. Williams would be a few £1,000s ahead, the lump sum £21,000 plus the 10,000 odd pension. But after less than 18 months from the date of ill health retirement, Mr. Williams will have received less financially than his comparator, who continues to work and receive that full-time salary. And indeed, that difference grows year by year because the salary earned by the comparator is greater than the pension received. the immediate windfall of that lump sum is soon bypassed by that full-time salary. The gap grows year on year into the comparator's retirement by £17,000 or so a year, and when the hypothetical comparator retires, he gets the lump sum we've set out in the second row on the right-hand side of just under £41,000, and for each subsequent year between then and projected date of mortality, the gap grows greater still. Our submission is, because Section 15 is not intended to be narrower than its predecessor, Section 3(1)A of the DDA, the fact that the outcome decided by the appeal courts below is different on the same facts under Section 15 than it would have been under Section 3(1)A shows in itself that the courts below have not properly construed Section 15 and have actually gone against the intention of Parliament, narrowing the intended protection for disabled persons. So we next make 4 submissions about the use of the context and the need for a broad scope of interpretation. Our first point is that we rely on the UN Convention of the Rights of Persons with Disabilities as part of our argument on the broad scope of protection and the need to respect the disabled individual. And our submission is, by adopting an objective test, the UN Convention is itself infringed. So I can be very brief on the role played by the Convention. It forms part of our domestic legal order since it was ratified by the UK in June 2009 and then by the EU in November 2009. And by way of statutory instrument, UK has declared that the UN Convention falls within the concept of an EU treaty under the 1972 Act, Section 1(2). That means it can be relied on without having to even go through the European directive. Here would be the Framework Directive. And in light of its status, courts and tribunals must interpret the legislation in a way which gives effects to the rights and protections set out in the UN Convention itself. And we will take you to the articles that we rely on in tab 3 of the First Authorities bundle, please. Firstly, please, to page 486. Article 1 of the UN Convention on the Rights of Persons with Disabilities sets out that the purpose of the Convention is to promote, protect and ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with disabilities and to promote respect for their inherent dignity. When looking at what is the definition of discrimination on the basis of disability under Article 2 below, about halfway down the page, we see that very broad reach of the definition here, in that it means any distinction, exclusion or restriction on the basis of disability which has the purpose or effect of impairing or nullifying the recognition, enjoyment or exercise on an equal basis with others of all human rights and fundamental freedoms in the political, economic, social, cultural, civil or any other field. It includes all forms of discrimination, including denial of reasonable accommodation. Moving then to 2 later articles, since an ill health retirement pension is a form of remuneration and a benefit, we go first to Article 27, which deals with work and employment. On page 489, please. And starting just 4 lines below little 1, state parties shall safeguard and promote the realisation of the right to work, including for those who acquire a disability during the course of employment by taking appropriate steps, including through legislation, to, and then down to little b, please, protect the rights of persons with disabilities on an equal basis with others to just and favourable conditions of work, including equal opportunities and equal remuneration for work of equal value. And just pausing there. We say that means receiving the same pay as the non-disabled person for doing the same job.
But how does that test, seeing the same pay for doing the same job, justify the comparator on MS 456 between someone who is doing work and someone who isn't?
Well, what we say one must take care to safeguard here is through legislation, is that you look as to the rights of the individual to not have disability impact on their remuneration. That's what's meant by equal remuneration for work of equal value. So that relates back to where Mr. Williams, we say, had his part-time salary used in the calculation of his enhanced benefits, although that was purely because of his disability. We would say, when looking at whether that was unfavourable treatment for him, applying the reasonable victim approach, the court should adopt that level to the scope of disadvantage and not any higher level, such as a purely objective test. Can I take you briefly to the last article we're concerned with, which is Article 28, Adequate Standard of Living and Social Protection. Top of page 491, please. At little 2, state parties recognise the right of persons with disabilities to social protection and to the enjoyment of that right without discrimination on the basis of disabilities, and shall take appropriate steps to safeguard and promote the realisation of this right, including measures, and then if we could jump straight to E, to ensure equal access by persons with disabilities to retirement benefits and programmes. And our submission is that's a link to pension benefits, and here Mr. Williams has complained about the discriminatory metric in the calculation of the pension. And in order to see the impact of the allegedly unfavourable treatment upon him, it's imperative, we say, to have regard to his subjective experience, albeit tempered by the reasonableness test. And so we say, how can the principles safeguarded here, the dignity of the individual disabled person and the diverse approach adopted, be taken into account if Section 15 is ignoring his experience by virtue of the adoption of a purely objective test? The next discrete point about the context is, does the interpretation of unfavourable treatment require a hurdle? And this is with reference to part of the judgment of Mr. Justice Langstaff when describing what would amount to unfavourable treatment. Could we please go back to the EAT judgment at paragraph 28, which is in your core volumes, at page 139.
Yes.
So at 28, Mr. Justice Langstaff says, 2 lines before the bottom of the page, in this use, it has the sense of placing a hurdle in front of or creating a particular difficulty for or disadvantaging a person because of something which arises in consequence of their disability. And he's talking about the word unfavourable should have the same meaning in both sections 15 and 18. The respondents have taken that phrase, hurdle or particular difficulty or disadvantage, to assert that in our examples that we raise, unfavourable treatment isn't a hurdle or difficulty. Our submission is that's simply a gloss on the statute. It doesn't actually help in advancing the interpretation of unfavourable treatment. But Mr. Williams' circumstances can be described as a disadvantage or hurdle. In this way, the requirement for him to work full-time in order for the enhanced benefit to be calculated on full-time earnings. That was the hurdle for Mr. Williams because he couldn't work full-time. Thirdly, a very brief point, which arises from the respondents saying that previously the courts have had no difficulty with the meaning of unfavourable treatment. They've referred to 2 cases, Interserve, and IPC Media and Miller. I don't need to take you to them now, but for your reference, tabs 13 and tabs 14. However, those cases turned not on the issue of unfavourable treatment, but on the reason for the treatment. They were concerned with causation. So those take us no further. Fourth brief point, what is the implication for section 18, the pregnancy discrimination section in the Equalities Act, if we are right that this low threshold should be used for ascertaining if unfavourable treatment has taken place? Our submission is there's no reason for concern about such a low threshold, because although Section 18 doesn't have the corresponding justification defence that Section 15 has, the test for causation under Section 18 is completely different. It's akin to direct discrimination. One has to be discriminating because of pregnancy and maternity itself, rather than something arising in consequence of, for us, the disability, or in 18, the pregnancy. So that's the built-in limitation to the section. It's about whether there's unfavourable treatment just for acts done because of pregnancy and maternity itself. I'm going to move on to the next area of our submissions about whether it's possible to have unfavourable treatment in the context of a benefit. We submit that the findings of the Court of Appeal and EAT amount to one not being able to have unfavourable treatment in the context of a benefit. And we will take you straight to the parts of the judgments that suggest that. Firstly, paragraph 29 on page 140 for volume. 5 lines down that paragraph.
So which paragraph again?
29, please.
Come.
In my judgment, treatment which is advantageous cannot be said to be unfavourable merely because it is thought it could have been more advantageous, or put the other way around, because it is insufficiently advantageous. And then he goes on to talk about the broad view, which we've already gone to. And that, my ladies and my lords, is echoed by the Court of Appeal in their judgment at page 122 in your key volume, at paragraphs 42 to 43. At the top of 42, Lord Justice Bean says, in the leading cases cited to us, the treatment complained of has been an act which itself disadvantages the claimant in some way. And at 43, the Court of Appeal says, again, that he says the case doesn't turn on a question of reasonable perception, in our submission not understanding the point that's being made to him about the need for the mixed subjective-objective approach. And he says a pension undoubtedly less advantageous or less favourable than that of a hypothetical comparator suddenly disabled by heart attack or stroke, but far more advantageous or favourable than it would be if he hadn't become permanently incapacitated.
Can I just ask you,
yes,
I'm not sure that you've got time to
yes,
respond to this now, but the concept of unfavourable suggests that you would have a neutral position, and some people would be treated favourably, and some people would be treated unfavourably in consideration with that neutral position. What's the neutral position here?
We say the neutral position is the full-time working, what Mr. Williams did without his disability interfering with his working. That's what needs to be considered for unfavourable treatment. And the reason...
it's the treatment that has to be unfavourable or favourable. That's probably the multiplicand.
Well, my lady, what we say is he was treated looking at his part-time working. The way to have treated him favourably, i.e. not unfavourably, would have been to have used his full-time hours, because our submission is, in order to maintain the same threshold of protection as existed prior to Malcolm, one has to take away the reason for the treatment as well. So the EAT are saying one can't have a complaint about something advantageous. And our submission is that arises from a confusion about what here was unfavourable treatment.
Can I follow up Lady Black's point, if I may? I mean, in the initial claim, I think it was contended that the appropriate course would be for the pension calculation to convert his part-time salary into its full-time equivalent and make a correspondent reduction of the period of the part-time employment.
That was put forward.
And that's not your case now?
He doesn't maintain that.
No, you've departed from that. Thank you.
So it's important to recall that the unfavourable treatment is not the receipt of the pension itself, but the incorporation of the discriminatory metric in the calculation of the enhanced element. So even if it's better to get a pension than not at all, it's still entirely possible to challenge a disability-related element of the calculation as unfavourable. Now, in our case, we've gone into some detail about how you can have unfavourable treatment in the context of a benefit. And because it seems that that's agreed by the respondents, we don't need to take you through everything we've said there. But we do emphasise that it certainly can be unfavourable treatment, even if it arises in the context of getting something advantageous, which is the case that happened here. We set out an example at paragraph 72 of our speaking note of where there's a generous maternity pay scheme which gives someone a woman who has had a child full pay for a full 12 months maternity leave, despite there being no statutory obligation to provide such a rate. That individual in her last few weeks of pregnancy works part-time because of pregnancy complications, and because of that, when her maternity pay under this company scheme is calculated, her part-time salary is used rather than her normal full-time salary. Our submission is that use of the part-time salary would be unfavourable treatment, even though she's getting an advantage, pay for when she's not at work, even if the scheme is generous, even if there's no statutory obligation to provide the rate and only women taking maternity leave are entitled to that. So we submit that the reasons relied on by the appeal courts below and the respondents, that is, you can't complain about something being insufficiently advantageous, are untenable both in that example and indeed in Mr. Williams' case. None of those points matter: generosity, no statutory obligation, only the disabled get it, as to the question of whether the metric in question is unfavourable. So it takes us no further that only the disabled are getting the benefit in the first place. That doesn't mean one ignores any disability-related discrimination within the advantage pension. The judgments below we submit only make sense if the treatment is being taken as the receipt of the pension as a whole. And there could be many, many examples where a particular group obtains a disadvantage, and it may well be that the fact that only a select group are getting it, or that it is a generous scheme, is relevant to objective justification. But what it certainly is not is relevant to the question of unfavourable treatment under section 15(1)(a). We've looked at the courts below saying his complaint is simply that it could have been better, or it's not good enough. And we next address that issue. We've set out in our speaking note at our paragraph 79 the part of Lord Justice Bean's decision from paragraph 49 at page 123 of the core bundle. He says there, no authority was cited to us to support the view that a disabled person treated advantageously in consequence of his disability, but not as advantageously as a person with a different disability or medical history would have been treated, has a valid claim for discrimination. If such a claim were valid, call into question the terms of pension schemes or contracts which confer increased benefits, and so on. The critical question can be put in this way: whether treatment which confers advantages on a disabled person but would have conferred greater advantages had his disability arisen more suddenly, amounts to unfavourable treatment within Section 15. In agreement with the President of the EAT, I would hold that it does not. We make 3 points about why this is the wrong approach. Firstly, the court here is misinterpreting what Mr. Williams relies on as the treatment. It's not the pension per se, but the metric within it. Secondly, when Lord Justice Bean says it would call into question those other kinds of schemes, we agree it would call into question those other kinds of schemes as to whether they contained unfavourable treatment within the meaning just of Section 15(1)(a), but his concern is too great, we submit, because it overlooks the availability of the objective justification defence, and his reluctance, as expressed there, is just what Baroness Hale warned against in the indirect discrimination case of Aesop, when looking at should the employer be wary of having to justify potentially discriminatory treatment. We've set out that paragraph of Aesop in our case at page 76, please. She was saying this with regard to the passing over of the burden in the context of indirect discrimination. Our submission is it's still pertinent in that Section 15 carries the same justification defence as Section 19. And her ladyship said there, a final salient feature is that it is always open to the respondent to show that his PCP is justified. In other words, that there is a good reason for the particular height requirement or the particular chest grade or particular CSA test. Some reluctance to reach this point can be detected in the cases, yet there should not be. There's no finding of unlawful discrimination until all 4 elements of the definition are met. The requirement to justify a PCP should not be seen as placing an unreasonable burden upon respondents, nor should it be seen as casting some sort of shadow or stigma upon them. There is no shame in it. We submit that Lord Justice Bean has shown a real reluctance to get to the stage which requires the employer to justify unfavourable treatment, so it's apt to rely on this paragraph, and particularly as there is, of course, with Section 15, no finding of unlawful discrimination until all elements of the cause of action are met. Section 15(1)(a) is simply a finding of unfavourable treatment and nothing unlawful. One has to wait till one gets later for that to be established.
Position in our case that justification would have to go back to the employment tribunal.
We accept that.
On the basis that they approached it in the wrong way, is that right?
It is, and also, as it's been rightly said by Mr. Justice Langstaff below, until you know what the unfavourable treatment is, you can't do the balancing test. And the third problem in paragraph 49 of Lord Justice Bean's decision is that he's asked the wrong question for a Section 15 claim. As I've pointed out already, comparing Mr. Williams to others who have different medical histories is simply the wrong approach. That would be akin to a Section 13 direct discrimination case. It's not what Mr. Williams relies on. And on another point we make about the point advantage is that the Court of Appeal ignores the fact that although the pension is obtained, Mr. Williams can never work again. He has permanent incapacity as a finding made in order for the receipt of the pension to be given. If someone chooses to stop working and then gets an early pension, that would be a windfall, but one has to temper the meaning of advantage where one's compelled to stop work due to incapacity. And indeed, the Court of Appeal have said at paragraph 42, I read that out to you at page 122 a moment ago, treatment complained of in an act which disadvantages the claimant in some way. There's no divergence with the claimant's experience here. He has been disadvantaged, whether from his perspective, that of the reasonable victim mixed test, or on purely objective basis. His pension was less because a disability-related metric was applied. So our reply to the points the courts below have made, there's no limit to what you want, is that they appear to have confused unfavourable with unlawful. And although the courts below did make references to objective justification, our submission is from the analysis of their judgments, they haven't truly considered the balance of Section 15 and the impact of the objective justification defence. For example, where Lord Justice Bean is very wary about the employers having an onus of justifying. And of course, because the justification exercise involves a balance, if the court thinks the discriminatory impact has been little or quite low, then it will be easier to establish justification. Our final point on the advantage point is, if the Court of Appeal is correct, how would anyone ever win a Section 15 claim about the reduction of a bonus for a reason related to disability? And there are many cases where that actually happens. There's a case called Land Registry against Houghton. In your first authorities bundle at tab 17, and if you could turn to page 703, please, you see from paragraph 10 that the respondent operates a discretionary bonus scheme, but one's, top of 704, one's ineligible to receive that bonus if you've got a formal warning in respect of your sickness absence during the relevant financial year. Page 704, paragraph 11, the claimants were disabled, they had sickness absences, and middle of the paragraph says each claimant received a warning, and those claimants therefore got no bonus. And the point about unfavourable treatment is made at page 706, please, paragraph 19. In the second line, PAT say that the Employment Tribunal found that in each case the absences leading to the warning were disability related. That type of warning automatically disentitled the claimants to the bonus. That is plainly sufficient to amount to unfavourable treatment, non-payment of bonus in consequence of the disability. Without the disability, each claimant would not have run up the level of sick absences leading to the bonus. That's why the bonus was not paid. Well, in our submission, we say there would still be unfavourable treatment here, even if those claimants had got half their bonus, say, rather than no bonus at all. And if the courts below were right, claimants only getting 50% of a bonus because of disability-related absences disentitling them to the full amount, would not be able to show any unfavourable treatment. And another answer to the accusation that you're simply complaining you could have got better, is that, of course, claims are not open-ended in terms of unfavourable treatment, let alone objective justification. So, for example, it's not possible for an employee to tenably claim sick pay for a greater amount of time than they've actually been absent from work. And Mr. Williams couldn't claim that his pension should be calculated on the basis of £1 million salary, which he never earned. So there's unlikely to be a case in which there's an open-ended claim to more than the non-disabled person would have received. We've got one more example about how readily disadvantage was established in another case, and that's the case of O'Hanlon, 2007 Court of Appeal judgment about disability discrimination concerning reduction in sick pay. And we'd ask you please to turn to tab 22 in Authorities Bundle number 2. Before I take you to part of the judgment in on page 840, can I just summarise for your ladyship and your lordship's benefit the brief facts of that case? One of the issues under consideration was the sick pay provision less favourable? There, employees got 6 months full pay, 6 months half pay, and then a lesser payment. Both the Court of Appeal, both the EAT and the Court of Appeal agreed that the reduction in pay after 12 and 6 months was less favourable treatment. And there was no argument, even advanced, that because sick pay is a benefit and that you receive pay without having to work, there could be no claim. And just taking you to what was actually being argued in the Court of Appeal, at the top of page 840, Lord Justice Hooper is reciting what had happened in the EAT. So that little 80 at the top of the page is from the EAT judgment. And there it said, the claimant does not dispute that she is effectively claiming full pay for the periods when she is not at work. But she says that on a proper analysis of the authorities, it is plain that she suffered less favourable treatment for a reason that related to her disability. And then you turn to page 841, middle of the page, at D, 87. This is still the EAT judgment here. It follows that in our judgment, this aspect of the appeal succeeds. There is what might be termed prima facie disability-related discrimination, and the only question, therefore, is whether it can be justified. The bold numbers that follow that are of the Court of Appeal judgment itself, and at para 86, Lord Justice Hooper says, in my view, the appeal tribunal is right for the reasons given by the appeal tribunal. Now, our submission following that is, if the respondent's stance in this case, and indeed the approach of the appeal courts below, were applied to Mr. Hanlon, there would have been a finding that there was no less favourable treatment, because this was an advantage to get sick pay at all. It was more generous than the law required. Only sick people get it, so it's not disadvantageous to them. And that's not even argued by the respondent in this case. And indeed, the representative for the revenue here made some bold submissions as to what Clark and Overcold really meant. You can see those at paragraph 85 on page, the bottom half of 841. I don't have time to take you through that now, but those arguments weren't even tried. O'Hanlon, we submit, is good law and it's not been overturned. Yet the finding there is completely at odds with the findings of the EAT and the Court of Appeal in Williams. And the particular bit of the EAT finding, which we say is contrary to this, is the sentence in paragraph 29 of Mr. Justice Langstaff's decision, where he says treatment which is advantageous cannot be said to be unfavourable merely because it's thought it could be more advantageous. That can't be set aside Mrs. Hanlon winning. So I move on to our fourth heading, which is consideration of the Court of Appeal's examples and also why we didn't advance other claims. And we raised the latter point because the respondent has raised the issue about why Mr. Williams, if he has such a good case on unfavourable treatment, didn't bring various other claims. And the first one of those is, why did Mr. Williams not claim that his accrued element of his ill health retirement pension should have been calculated using full-time pay? The accrued element was worked out using a career average, and Mr. Williams did not challenge that, but not because he agrees it wouldn't be unfavourable treatment, but because a calculation averaging pay would be more likely to be justified. And the reason for that is because the career average, of course, takes into account full-time as well as part-time hours worked. So it could be said that it was proportionate to work in part-time disability through an average. Mr. Williams would recognise that that kind of case, complaining about averaging as unfavourable treatment, would be more difficult to justify as challenge as unjustified treatment, that is unlawful overall. But we do maintain that it would still pass that first hurdle of being unfavourable treatment because of the need to take away the impact of disability from the treatment suffered by the claimant. And if one applies that helpful litmus test, would such treatment have been unfavourable under section 3.1a of the DDA? Even looking at the accrued element, the correct Clark and Novikol comparator would have been able to work full-time throughout. And we say our submission on that is borne out by what the Code of Practice says about pensions and disability discrimination, where under the reasonable adjustments guidance, it points out that using a career average is often a fairer outcome. And whilst it does that under the reasonable adjustments part of the Code of Practice, our submission is that would apply equally to the outcome on justification. You see that part of the Code of Practice in your bundles at tab 33, page 1063, please. Tab 33, 1063. It's the example at the bottom of that page, at the top of that page, paragraph 14.44. I don't have time to take you through that in detail now, but we do rely on that. But we asked the respondents a question, would they agree it would have been unfavourable to have used a final salary figure rather than a career average figure for the accrued element of the pension? In their case, the respondents say it would be potentially unfair to calculate a pension generally based on final salary instead of an average, and they reference the part of the code we've just taken you to. Our submission is adopting that form of averaging for the accrued element implicitly shows that they implicitly accept that fairness does require averaging for the accrued element of the ill health retirement pension as well. And our submission is that it follows when looking at what is unfavourable treatment that firstly, there's no rational basis for distinguishing between a regular pension at normal pensional date and the accrued element of this ill health retirement pension. And we say, secondly, the same logic should apply to the enhanced element. So our follow-up question to the respondent would be, if they agree with our first proposition that fairness requires averaging for the accrued element, why would that logic not also apply for the enhanced element in terms of unfavourable treatment? The next question the respondent says is that, taking our argument to its logical conclusion, surely Mr. Williams should have claimed full-time pay when working part-time. And the difference is here, although our submission is he could have brought such a claim after his hours went down to part-time, such a claim would also be far more likely to be justified. And we also submit that whilst it is rare that there is a finding that an employer is legally obliged to pay full-time pay for part-time work, whether it's unlawful is also distinct from it being unfavourable within the meaning of the provision we're concerned with. And the question about whether an employer is ever obliged to pay an employee when they are not at work in the context of disability discrimination is certainly not a foreground conclusion and has come up in several places in the area of reasonable adjustments. That's a Section 20 claim of the Equality Act, but it considers similar questions to the matters considered by the Court of Appeal here. And with this in mind, we'd refer you to go to the case of Powell, please, at tab 36. It's the back of your second authorities bundle. Mr. Powell was an engineer whose disability meant he had to be moved to a different role, that of a key runner, and that different role had a lower salary. He'd only been moved because of his disability, and the court were considering here whether it was a reasonable adjustment to maintain his original pay. And they say, in the headnote, please, on the right-hand column of 1126, there's no reason in principle why Section 23 should be read as excluding any requirement upon an employer to protect an employee's pay in conjunction with other measures to discount the employee's disadvantage through disability. The question will be, is it reasonable? Many forms of measure which it will be reasonable for an employer to take will involve a cost to the employer. There's no reason why pay protection, another form of cost, should be excluded as a step. And they give examples of how that could take place and say, towards the end of that paragraph, there's no reason in principle why the one should be a step but the other should not. The latter may be less costly than the former. It's not expected it's an everyday event for an ET to conclude that an employer is required to make up an employee's pay long term, but one can envisage cases where this may be a reasonable adjustment for an employer to make as part of a package of adjustments to get an employee back to or keep an employee in work. So we rely on that in order to say it could well be unfavourable treatment to reduce a disabled person's pay from its former level once they're incapable of working their normal hours due to disability. And even in the EAT, in our case, Mr. Justice Langstaff left that question open. And I cross-refer you, please, to paragraph 34 at page 143 in your core volume, where at the very bottom, I don't have time to take you through the full paragraph, but in the very bottom of the page, Mr. Justice Langstaff says, though I'm less certain that such a conclusion can necessarily be excluded in all circumstances, beyond which it is unreasonable to do, I'd accept any argument advancing it will usually face at least a significant uphill struggle. And if there are any circumstances in which a case succeeds, they're likely to be exceptional. Our submission is Mr. Justice Langstaff was right not to close the door on those claims, but Mr. Williams recognised the risk on the merits overall of claiming full-time pay for part-time work and took the pragmatic decision not to bring such a claim, and that's not inconsistent with his Section 15 claim. I now turn to the examples that the Court of Appeal posed in their judgment, starting at paragraph 55 on page 122 of the core volume, please. The first example is where Lord Justice Bean considers whether the obligation to pay full-time pay for part-time work would exist if the role was part-time from the outset. We say the example set out in this paragraph is making a distinction between a job which has always been part-time and having to transfer from full-time to part-time hours. The reason why counsel for Mr. Williams at the bottom of paragraph 45 agreed there'd be no unfavourable treatment there, because if there's a job which is only ever part-time, under the former Clark and Overcole test, the claimant wouldn't be able to establish less favourable treatment when you take away the reason for the treatment, because the role would still be part-time, and non-disabled persons applying for it would also work part-time and receive part-time pay. There could be a difference between this and if you apply for a full-time role to begin with, but in those circumstances, if you've worked part-time for the majority of your career, it might be easier to establish objective justification, taking into account proportionality. And that was similar to the next example, at paragraph 46 that the court posed, where an individual, a disabled employee, can't maintain their full-time hours. But there are two major errors with the analysis in paragraph 46. The first one is to say that the only difference between the two is that in the second one, the individual worked part-time for a short period. That's wrong, because in our first example, at paragraph 45, the role was only ever part-time, so part-time pay is all one could get for it, disabled or not. But in paragraph 46, the second error by Lord Justice Bean is where he says in the middle of that paragraph, it would be very surprising if on those facts he was entitled to a pension as if he'd worked full-time throughout his employment. Well, entitled suggests he would win the claim outright. No consideration about what would happen at the justification stage. We would agree that the period that one had worked part-time versus full-time would be relevant to the justification question under the understanding of proportionality. But that's not what we're looking for here. We're simply looking at, in that situation, would it be unfavourable under section 15(1)(a). We do emphasise here that our case is that paying a career average would be unfavourable treatment because one needs to take out the disability-related treatment in question. Respondents raised an issue about part of our case here, and I'd like to clarify that. Please could you turn to page 63 in our case. What we've meant to express that it would only be neutral treatment under this provision to calculate pension based on full-time hours worked. And we'd ask you, looking at paragraph 65, to actually insert the words full-time before the words hours, as that would make the meaning of our argument rather clearer. What we're saying here is that it would only be neutral treatment to calculate pension based on full-time hours worked.
So take out the word he actually worked.
Yes.
So it's not just adding full-time.
Yes, thank you.
So that's why I was asking whether you departed from the initial claim, because that seemed to be tying back into the initial claim.
Well, we apologise for any confusion. That's why I wanted specifically to correct that.
So it reflects full-time hours over the course of his career.
Thank you, my lord.
Yes, thank you.
So our conclusion on those Court of Appeal examples that were examined is that the Court of Appeal seems to have demonstrated its misunderstanding of Section 15 by firstly failing to take into account the low threshold of disadvantage required, and secondly overlooking the balancing of the both parties' interests which takes place at the objective justification stage. And in particular, the Court of Appeal was overly cautious about throwing the onus of justification to the respondent. That concern was misplaced for the reason we've already said. And it's at paragraph 45 on 122 that Lord Justice Bean says it could hardly be said to have been Parliament's intention that he should be able to claim he's been the victim of unfavourable treatment and throw the onus onto the employers to establish the part-time salary is a proportionate means of achieving legitimate aim. That example at 45, we've said, in any case, is distinct and different, or we wouldn't say that amounted to unfavourable treatment. So we conclude by replying to the points that the respondents have made in their case at paragraph 96 on page 103 of your 4 volumes, please.
Can you not deal with this in your reply?
I'm very happy to.
Good.
Can I just have one moment?
Yes?
My lords, my lady, there's one more point I wanted to make clear to you, and I'll come back on the disposal point in reply as well.
Yes.
There's a point of difference between us there. I want to make one more point absolutely clear, which is when asked about did Shamoon specifically advocate the mixed subjective-objective test, we ask you to look at those the authorities in our bundle, which I haven't had time to go through one by one, to set out where they specifically identify the victims, the perspective of the victim tempered by a reasonable test. And those are firstly...
Which is the best case, or the most authoritative?
Well, if you've got a list, I'm happy to receive.
I'll give the ones I've got to you. I think Shamoon is the best one, but not the paragraph we looked at before, because, as we said, that didn't specifically identify to the specific degree the individual victim. But let me give you these references.
Is there another paragraph in Shamoon? Then?
Tab 27, paragraph 105, page 997 of Shamoon.
Does this appear in your speaking note?
No.
This doesn't appear in your speaking note.
No, this is research by your learned junior this
My
morning.
juniors very helpfully got me these additional references. They're not
I
in
think your note gives us plenty of homework as it is, so this is adding to the
Yes.
task. Right, let's have them then.
So Shamoon at paragraph 105, page 997. A detriment exists if a reasonable worker might take the view that the treatment was in all the circumstances to his detriment must be applied by considering the issue from the point of view of the victim. So there's that missing part which we didn't have in paragraph 30.
Well, that's Lord Scott expressing a reservation about the way it's put by Mr. Justice Brightman.
Well, following on from that, we also have in St Helens, tab 25, paragraph 66 at 9 to 9, where at 67, you need to see 66 and 67.
So this is tab
It's tab 25.
25, thank you.
What Lord Neuberger is saying at 66 is, under the victimisation provisions, it's primarily from the perspective of the alleged victim that one determines the question whether or not any detriment, in this case under section 62B, has been suffered. However, the reasoning in Khan suggests that the questioning whether a particular act can be said to be victimisation must be judged from the point of view of the alleged discriminator. Of course, the words "by reason that" require one to consider why the employer has taken the particular act, and that we must assess the act of victimisation from the employer's point of view. However, in considering whether the act has caused detriment, one must view the issue from the point of view of the alleged victim. In that connection, Brightman and LJ said in MOD and Jeremiah that a detriment exists if a reasonable worker would or might take the view that treatment was in all circumstances to his detriment. That observation was cited with approval in Khan and with approval in Shamoon. At paragraph 35, Lord Hope described the test as materiality and said unjustified sense of grievance can't amount to detriment. In the same case, at paragraph 105, Lord Scott of Foscue, after quoting Brightman LJ's observation, added, if the victim's opinion that the treatment was to his or her detriment is a reasonable one to hold, that ought, in my opinion, to suffice. That appears in itself at the bottom of the second paragraph of the head note of that case at page 920. So I'm going to stop with those two additional references, and that will complete what we've said about the mixed subjective-objective test being the key one to apply in less unfavourable treatment under section 15(1)A of the Equality Act. I will come back to conclude and to deal with disposal in my reply, unless I can help your ladyship or your lordships.
Thank you very much.
Those are our submissions.
Ms. Dobby? Mr. Bryant.
My lords, my lady, I have just over 10 minutes, I think, before I
12.
assume we'll be breaking.
Yes.
I will refer to the parties as Melinda Frembus-Krasno has as the claimant and the respondents. I think that's how they're referred to in pretty much all of the documentation, and I'll adopt the same approach. The structure of my submissions is going to be along the following lines. First, I'll begin in a moment to say something about the pension scheme with which this case is concerned. You haven't heard much about it in Learned Friends' oral submissions, but in my submission it is central to this case, and it is central to the circumstances in which the statutory question has to be considered. I'll then say a little bit about the structure of the Equality Act. Again, as Krasno has gone through some aspects of it at some speed for understandable reasons, but I'll perhaps take a few more minutes just to explain the relevant parts and sections that I say are again relevant to the context in which one needs to construe section 15. I'll say something very briefly about the facts. I'll then summarise the respondent's case and then come to respond to the various points raised in the claimant's case and indeed in Melanie Friend's speaking note and her oral submissions this morning, insofar as they are different from what is in the notice of appeal and in the claimant's case, because there are some changes. You Lordships and my lady will be aware there is no authority at this level, or indeed at the Court of Appeal level, apart from this case, on the meaning of unfavourable or unfavourably. Again, I will use the two terms interchangeably, either in the context of section 15, the disability provision, or section 17 and 18, the pregnancy discrimination provisions. I'll come to those in my canter, as I hope it will be through the Equality Act in due course and after lunch. So my first topic is the scheme itself, and if you will permit me, I'll spend a little time going through this, because it is, as I say, crucial to the context in which this claim has to be considered. We are concerned with a trust-based occupational pension scheme. The first respondents are the trustees to the scheme, and the second respondent is the principal employer, the university. You have the governing provisions in the documentation. It's in part 2 of the appendix. It's pages 2, 3, 5 and following. Unless you invite me to, I won't take you to the specific provisions. It was and remains a defined benefit scheme, usually referred to as by the abbreviation DB, and that means exactly what it says. The benefits are defined in the rules of the scheme. Typically, DB benefits are much more generous than a DC scheme, a defined contribution scheme, where typically money purchase, you put your money in, you hope it gains some investment return, sometimes it doesn't, and you get out what you've put in plus any investment return at retirement. Defined benefit, very different. You get the benefits that are set out in the rules themselves. Other than in the context of statutory public sector schemes, DB accrual now is increasingly rare. Accrual in this scheme, again typical across private sector schemes at the time, was with a multiplier of 1/80th. Now, I know multiplier and multiplicand have been used both in comment this morning and in the documentation. In terms of accrual, the typical term would be multiplier. It's an 80th. In this scheme, as again in other schemes, it used to be a 60th, but for our purposes, an 80th will do. Essentially, that means an employee accrues pension benefits equivalent to 1/80th of their pensionable salary for each year of pensionable service. At the time the claimant joined the scheme, and indeed his employment with the second respondent at the university, which was in the year 2000, I think June from memory, the scheme operated on a final salary basis. It was a final salary accrual scheme. And the benefits available at retirement were simply calculated as number of years pensionable service times the multiplier, an 80th, times final pensionable salary, i.e. pensionable salary at date of retirement. That potentially gave rise to, I think, as I've put it, possible unfairness if, for example, someone's salary was reduced significantly just before retirement, for example, through part-time working, perhaps because of something relating to disability. It could have an unfortunate effect on pension benefits if they're simply calculated on the basis of final salary. But this scheme, unlike others, but this scheme catered for that by calculating benefits for any period of part-time service on the basis of a full-time equivalent salary, but with a corresponding reduction in the period of pensionable service. That formulation may sound familiar to your lordships and my lady, because it's exactly what the Equality and Human Rights Commission recommends as a reasonable adjustment in the Code of Practice, and I'll come to that point after lunch. Some calculations are set out in the pleadings as they were before the tribunal, but unless you invite me to, I won't take you through those. I'm sure the effect and the mathematics will be obvious if one is taking, say, someone who has had a number of years full-time service and then they go to part-time just before retirement. If you calculate their pension benefits simply on the basis of their part-time salary at retirement, as Milena Friend would put it, it ignores the fact that they were working full-time for many years. If you treat the part-time years as full-time equivalent, but you reduce the number of years accordingly, so say 3 years part-time service, you would 3 years part-time service at half pay, say, you would use full pay as the multiplicand, and you would reduce the period of pensionable service by a half correspondingly. That solved the potential problem of part-time service in this scheme, and that has always been the case for this scheme, certainly during the material period with which we're concerned from 2000 onwards. As was identified during Ms Krasnow's submissions earlier this morning, the claimant's original case as put before the Employment Tribunal, and indeed when he raised the matter with the respondents shortly after his ill health retirement, was that he said that approach should have been adopted in respect of his the enhanced element, as it's been called by my learned friend, of his pension calculation. And indeed, I note from Milena Friend's submissions a short while ago, she expressly relies on paragraph 14.44 of the EHRC Code of Practice, which suggests that would be an appropriate adjustment for a scheme to make. The difficulty with that is that would result in exactly the same pension benefits as are currently being received by the claimant. That presumably is why he abandoned that claim before the tribunal. But it's interesting, I say, that Milena Friend appears to rely on that suggestion for the purposes of this appeal.
Is that coincidental that they happen to match those two figures?
My Lord, I don't know the answer to that question. I can say that the adoption by this scheme of that approach predates by some years the Code of Practice from the EHRC. Whether the EHRC was aware of the fact that this, and indeed a large number of other schemes, adopt the same approach, I don't know whether that influenced the Code of Practice. As I've said, that this scheme was a final salary scheme, benefits accrued on a final salary basis. In 2009, so during the relevant period of the claimant's pensionable service, while he was still accruing benefits, the scheme underwent a significant amendment to the benefit structure. It changed the basis of accrual from final salary to what's referred to as CARE, Career Average Revalued Earnings. It's still a defined benefit accrual basis, but for each year of service, a separate calculation is undertaken based on the pensionable salary received in that particular year, again times the relevant multiplier, say 80ths, and then that is treated as a notional benefit pot by the scheme actuaries, and it is revalued every year from then until retirement by an inflationary measure. At the time it was RPI under this scheme. Under CARE accrual, variations in salary from year to year, the potential problem I've already identified with the final salary accrual basis, are automatically taken into account. The problem simply goes away. see I have 5 seconds to go until 1 o'clock. I wonder if that's a convenient time.
No, we won't require you to go to 5 seconds. Sit again at 2 o'clock.